Evicting a tenant can seem like a complicated undertaking, but in this video, we'll quickly explain eviction laws in Washington and how to recover your property in 5 simple steps. First, what is an eviction? Eviction is the process of legally removing a tenant. It's illegal for a landlord to change locks or physically remove a tenant themselves. So, if the renter refuses to leave after violating their lease, you must seek an eviction from the court. The process for simply terminating a lease differs from that of an eviction. Lease terminations require proper notice from the landlord or tenant, and state requirements can be found on our website. Legal reasons for eviction in Washington. A landlord only has grounds to evict a tenant for reasons allowable in the state. The first step in the eviction process is to give the lessee one of the following notices to quit. Non-payment of rent. If the tenant is late on rent, you can serve a 14-day notice to pay or quit. This gives them 14 days to pay the rent in full along with any penalties or vacate the property. Non-compliance. If the tenant commits a lease violation such as harboring an unauthorized pet or unpermitted subletting, a non-compliance notice gives them 10 days to either comply with the lease or vacate the property. Illegal activity. Landlords can choose to make certain violations like illegal activity incurable. If your tenant engages in illegal activity while living on the premises, you can serve them a 3-day notice to quit, which requires them to leave within 3 days with no option to remedy the violation. Rent grace period. In Washington, there is no rent grace period. Rent is due on the due date. An eviction notice can be served if the rent is only 1 day late. 5 steps to legally evicting a tenant in Washington. Serve the notice to quit. Choose the form you need and download or fill it out on eForms.com. Serve the notice and retain proof of service, such as a return receipt requested via USPS. If the breach is curable, you must wait for the specified number of days allowed by the state before taking further action. File eviction papers with the court. If the tenant hasn't fixed the issue and remains on the property, you can proceed to the Superior Court where the property is located. You'll need to file an unlawful detainer action, which includes the following forms: complaint and a summons. Serve the court documents. The tenant now needs to be made aware of the case filed against them. Have the documents served on the tenant by someone other than yourself. The person serving the tenant will have to certify that the tenant was properly served and file their certificate of service with the court. The tenant will have a minimum of 6 days to respond by using the answer form. Default judgment or hearing. If the tenant doesn't respond, the court will issue a default judgment, and the landlord can apply for a writ of restitution. If the tenant does answer, the landlord will have to file a motion for an order to show cause, in which case the court will set a hearing date. Attend the hearing. At the hearing, the judge will reach a ruling. If the tenant doesn't attend, or if the judge rules in your favor, a writ of restitution will be issued, which orders the tenant to vacate. If they still don't leave, the writ will also authorize the sheriff to remove the tenant. Damages. Often the tenant's security deposit does not cover total losses. If damages are not awarded at the hearing, you may be able to recover past due rent and court fees through small claims court. Now you can get eviction proceedings started. Get eviction forms, court documents, and all other information you'll need at the link below for free.